And what about the possibility of apprehending him later? Are you factoring that into your decision today, your opinion today?
Yes. So when the threat being presented is the threat of escape, it is important to note that we're talking about the threat of escaping custody right now.
Why he didn't mention the
There are
girlfriend
a
in
number
the car
of
and the
situations
restraining order.
where
This doesn't solve that problem.
Benefits or officer safety benefits to not arresting someone immediately to arresting them later. Of course, you have to know who they are and have some idea of where to find them. In this case, the officers had information about who Mr. Wright was, who his brother was, their various addresses,
not who the girl
contact
was.
information.
That's the problem.
So although he
With
did
the order of
present
protection,
the imminent threat of
that could have
escape,
been the person in the car.
it certainly factors into the analysis that he was unlikely to avoid future apprehension in a situation like that.
Let him go.
Officers
Let him go.
typically
That's what they're trying to say.
either go and get him on the
There are
outstanding warrant or have new warrants written
Tens
out
to hundreds of thousands of
there.
outstanding warrants that are in excess of months of time.
Why would he allow himself to be arrested later? Right?
And
Apparently, you can just
did
you
all
attempt to
also
flee, they have to let you go.
I have no further questions, Your Honor. Thank you.
Okay.
Yeah, could we have one more sidebar before we start?
Sure.
They want to go into something good. They got something coming up.
Yeah.
Your Honor, we'd like to have EMS standing by for this witness.
Okay, Mr. Ing, you cited 702. First of all, the question is whether or not the state opened up the door to evidence concerning Dante Wright's prior fleeing incidents.
Ooh.
The expert opined that a reasonable officer in Officer Potter's position could have concluded that Mr. Wright presented an imminent threat of escape, but was unlikely to avoid later apprehension, in justifying his decision that taser was inappropriate.
What a
So,
catch.
Go ahead. 703
Wow.
or 703. Was 703?
703.
Because he resisted before.
So 703 is what we're relying on.
They did open the door.
See if the judge allows it.
Okay. And that does state that the court may admit the data under this rule. Excuse me, I can't read this.
Challenging the expertise.
Well, if the expert is relying on certain facts in rendering his opinion, I think that we're entitled
It's fair game.
Yep.
Boom.
Mr. Franklin is giving me an opportunity to tell me why the door hasn't been opened. A limiting instruction is always possible.
Yeah, great.
Yeah, but
Go
you
ahead. I'll
opened the
take it with
door.
limiting instruction.
Rule 703 deals with underlying an expert opinion. And it's basically
He was not offering an expert opinion there.
indicates that all of the facts and data relied on by the expert may be
even know
provided
how to
to
argue
the expert at or before the hearing. If a type reasonably relied upon by experts in the field, the facts or data need not be admissible in evidence. And so that's what paragraph A is about. Paragraph B is about the underlying expert data must be independently admissible in order to be received upon direct examination, provided that, so the first part of paragraph B is about direct examination and how it's restricted there. That last sentence then refers to that underlying data. It doesn't say, but on cross-examination, they can do whatever they want. It's related to the previous
Based on the way
sentences,
you laid it out, yes.
Well,
discussion
what
of
difference
the
did
underlying
I
data.
make
So
from what actually
703B is not a
Was
freestanding
there something I
rule
didn't add?
of admissibility and cross-examination. Evidence still has to be admissible and relevant.
If it's
You have
admissible,
ruled
then it opens the
that
door.
any prior conduct of Mr. Wright that is not known to Officer Potter is inadmissible and irrelevant because
No, but he's giving an expert opinion now.
what a reasonable officer knew in Officer Potter's position. That's exactly what this witness testified to. A reasonable officer in Officer Potter's position would have known that he had been identified and could be potentially apprehended later. He didn't guarantee it was going to happen. He said that a reasonable officer would have known that. Now, that might have been wrong. That's not what he's saying. What he's saying is a reasonable officer at that moment would have.
Our
understood
expert was
that.
incorrect.
It doesn't change anything that there is the unknown incidents unknown to Officer Potter because a reasonable officer in that position wouldn't have had that information. So no door has been opened to put in what is essentially character evidence under 404B. That's what they're trying to do here, is to make it look like Mr. Wright wanted to flee. That's not the issue, right? The issue is what Officer Potter knew to apply that reasonable officer standard.
And there isn't any evidence that, obviously, right now, that Officer Potter was aware that he had fled in the past and done whatever acts to evade warrants or whatever. If Officer Potter wasn't aware of that, I believe it's covered under my prior ruling that any prior bad acts, alleged bad acts on the part of Dante Wright would not be admissible.
Yeah, speak to that.
Yes.
Their expert testified about the prior bad acts. I mean,
Well, the expert has testified he's reviewed thousands of pages. We don't believe he's reviewed a inch-thick file on Dante Wright on every time he gets arrested, he tries to escape. Every court appearance he misses. Every time he can get away, he can get away. And so now we have an expert who's articulated that this really shouldn't have been a lethal force matter. You know, no taser should have been shot because eventually we'll find this kid. I mean, that's his opinion. And it's false. We'll find him. He'll be easily arrested. No big deal. And so they've got an articulated opinion they put forth to these jurors. They're writing it
That's
down.
false
like
to the
crazy on their
facts.
notes. A few of them are anyway. And we need to rebut the falsehood of that opinion. And, you know, I realize your ruling was that since you didn't know about certain things about Dante Wright, you know, we're limited. But I briefed the 703 issue, and you didn't rule on that yet. And I was waiting for this issue to either not be brought up or to be introduced into evidence. And now they've introduced a false predicate into the trial.
whew.
And a false inference and false facts denies us due process. NAPU versus Illinois. We
Whoa!
either have to correct it, or if your ruling is that we can't ask about it, I have to move for mistrial, and we will come in after the break with a thick packet, and I'll make an offer of proof of every time this kid has run away and not been found.
Okay.
This is
Whoa.
a lawyer right here, folks. This is a lawyer.
Hey, fuck you, and the clique that you came with.
Mr. Frank,
Let the judge know.
Yes, Your Honor, please, thank you. And I will not comment.
Please let me talk. Please, please, please.
You can see clearly what the real purpose of trying to offer this evidence is.
You offered
It's
it.
404B, it's character evidence.
Yeah,
But-
you offered it.
There has been no false impression given to the jury because the witness's entire testimony was couched in terms of what a reasonable officer would have done or known, or what would have been, what they would have done based on what that officer knew at the time. That's been the entire context of his testimony. He never misrepresented that to the jury. He never said, that he was guaranteeing they would have caught him later. That's not his opinion. So his opinion was carefully stated, appropriately stated, and did not open the door to any of this stuff. Whether it's an inch thick or not, none of it was known to Officer Potter, and it's not relevant.
Okay. I'm going to take a break and think about that. So I'll be back in 5 minutes, and I'm just going to read his expert opinions again, and I am concerned about this because
You have to
I
be
do
concerned
think
about
that
this.
the jury has gotten the impression that
That you could just let him go and get him later, and it would know.
apprehended later. And there is a basis for believing that he wouldn't have. So I'll take a break. I'll be back in 5.
Wow. Again, it's example after example that Paul Eng and Earl Grey are fantastic attorneys. They are well prepared.
Yes,
I mean, catching this based on that statement on the
we
fly.
missed it.
Not only that, not only did they have that objection ready, they've briefed this to the court ahead of time.
Well, welcome everyone.
Like,
Tim Blotz here in the Fox 9 newsroom.
They anticipated the possibility that someone might allege that Dante Wright would be caught later based on this expert's report, probably is where the basis is. And then they just waited. He just waited at trial. If this comes up, I'm going to nail him on it. It came up, he drops it, and he says, Your Honor, if this is allowed without us being able to rebut it, mistrial, and here's a citation for you. He was set and ready to go. And that is, we talked a lot during the Chauvin, or not the Chauvin trial, the Rittenhouse trial, about the sort of dispassionate approach that it seemed that their lawyers were taking. Do you have any impression at all that Paul Eng and Earl Grey aren't vigorously and zealously representing Kim Potter?
Yep.
I mean, that's the representation you pay for and hope to get. I mean, no matter how much you're paying, this is what you hope you get out of it. And they're worth every penny. Even if they lose this motion, they're worth every penny just for raising it and catching it on this small issue. But wow.
It's tough because you definitely don't want propensity evidence to get in. So that's one issue, especially the victim's character evidence. But the fact of the matter is, he essentially said, well, you should have let him go in and caught him at no risk to anyone later, right? The better option would have been to catch him later, because he was no risk to officers. We already knew who he was. We could have easily caught him later. And that's the impression the jury took. Okay, yeah, it would have been safer to look at him later. But if they said, no, every other time we've tried to arrest him, he's tried to escape, and we got something that's 1 inch thick showing every other time. So what he's saying is a misrepresentation of what the actual facts on the ground is. So now you have this thing where his opinion says one thing, but the reality is something totally different. And that's what I think they got him on, because the reality is not his opinion is one thing, but the reality is something different.
Yep. Yeah.
And as the defense says, they put up a false predicate, right? They made this representation to the jury, and it's not true.
And that's the thing. And
it's like an as-applied test, right? Maybe generally that would be true, but evidence exists that for this particular defendant, we know that's not true because of his prior egregious failure to comply with arrest, always flees, never shows up to court.
And they were trying to coach it into, well, what did she know at the time? But they're saying, well, that's irrelevant, because you said what a reasonable officer perceive at that moment. But you're saying that the conclusion is that it would be safer in more or less all these occasions to let the guy go and get a thing. And that's where you missed it. If you'd have just said, hey, she didn't know this, that's one thing, but making it seem like in all these situations it would be safer. No, in this situation, obviously would have been not.
The expert could have said, well, for all she knew, he could have been captured later. But that's not what he said. He said, as a general blanket statement, if you know you can, if you have the person's name, you can just arrest them later.
Right.
And that's not true on this state. And that's not true here. Boom.
Yeah. And it's also not true because of other testimony raised by the state. Remember, all testimony at this point is elicited from state's witnesses, but testimony that he's not living at home, that the person in the car with him has not been identified, and that he's actually living with the person who has not been identified, that he's staying there. not staying at home. We also have interesting statement from the mother on the phone asking about if he has any warrants outstanding. You have any warrants out for you? You have any warrants? These are all facts that are known, not necessarily to Kim Potter, except she does know that he has a warrant outstanding. She does know that for sure.
The girl's not identified. There's an order of protection.
Right.
She knows that.
But these facts are before the court, and they were brought by state's witnesses. They were offered, I believe, even on direct examination for many of them. So Dante Wright's character has been and is a part of this case. His propensity. But am I not mistaken that propensity evidence is allowed to establish a pattern? Right? Propensity evidence is allowed to establish a pattern of behavior. If he has a pattern of fleeing officers.
No. Because you can't use character to show that someone acted in conformity with past conduct. We can show it for something like motive, unique signature of a crime,
modus operandi.
Yeah, modus operandi. But
if
you're saying
repetitive flight from arrest,
that might, I think that might run afoul of the rule, because if the evidence is that, you always think about it like, if you're saying he's running now because he's more likely to have run now because he ran before, that wouldn't be enough. So you would need,
I don't know.
I think
it's a closer call than that.
So here's
he gets into a lot of fistfights. That's different than, if a burglar always enters a home through a second story window, that can be introduced because it's modus operandi.
That is introduced. Yeah.
So rule 406 is habit, routine, or habit or routine practice, but that's not the one I'm thinking of, I think. But
no, you're looking at the exception. You're looking at 404. I think you're looking at 404B, character evidence, the exceptions. It has a list of them, like motive, signature of crime.
For defendant or victim. Let's see. Defendant may offer evidence of the defendant's pertinent trait. Let's see.
The question someone in the comments is asking, isn't there something about if one officer knows something, they're all imputed to know something? That applies to whether or not there's probable cause. It doesn't necessarily apply in a use of force context.
Here it is. I got it. It's 404B. Crimes are in the acts, permitted uses. So you can use it to show motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. So that's what you can use character evidence for.
Intent.
Motive, opportunity, intent. Yeah. So I think Andrew is right with this, because you can show his intent.
I mean, I'm not sure I'm right. I don't feel strongly about it, but I think the argument is there to be made.
Yeah.
Yeah. In other words,
I wouldn't die on this point, but
in other words, I was saying that I thought it was absolutely not, but I think your recitation of it's better. I think it's an argument. I didn't think it was an argument before,
because it's a very specific pattern of behavior. It's not just a character. Anyway, I would feel comfortable making the argument with a straight face.
So are they going to let it in or not? They're bringing the jury back in.
I wonder if the...
Okay, please be seated. All right. Is there a cross?
Oh, she must have told the parties separately. Okay, let's go, baby.
Here we go.
I'm going to ask you some questions pertaining to your report and your testimony today. Let me get this right. What your last piece of testimony was that the officers attempted to handcuff Mr. Wright because they had his address and name, and it was a minor violation, that they should have just let him go. Is that what you're saying?
No, that mischaracterizes my testimony and opinions. He was unlikely to avoid future apprehension.
What are you saying about it? I thought you said that they should let him go because they had his name and address. Is that what you said?
No, that's not what I said. He was unlikely to avoid future apprehension.
Okay, well then I misheard you. What did you say? They should let him go?
No, I did not say they should let him go.
What did you say?
He was unlikely to avoid future apprehension. I said that the fact they had identified him and had his address is a relevant consideration in balancing the threat of escape or evasion.
Of what? I'm sorry.
The threat of escape or evasion.
Okay, and if he attempted to escape, what should the officers have done?
Use reasonable force to prevent the escape.
And they do that when they were trying to stop him from escaping?
Are you asking me in this case? No.
They didn't. And
At an early point, I would say yes, although we didn't talk about that. But at the point of using deadly force, no. As I testified, that was excessive and unreasonable.
You testified the taser was
inappropriate
too.
and inconsistent with generally accepted police practices.
yes, but I was not talking about deadly force. I was talking about your first opinion in your report about using the taser. And your report seemed to reflect that because they would find him some other time or somebody else would get him, that they should not have tried to stop him. Is that what your report says?
It's not, no. Unlikely to avoid future apprehension.
Okay.
That's what he testified to. Hey, atheist for the cause. Fuck you.
So pour out an art bag about more of love for spirits flow as the ones who get unemployed. So pour out a glass for the team post on Twitter as we hear Lost Planning tonight. From the wide shores of Nam to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the